So, what happens when a single homeowner decides to take on their entire HOA board? It sounds like a movie plot, but this is a real life David versus Goliath story. We've cracked open the actual court documents to give you a step by step breakdown of how a neighborhood disagreement turned into a full blown legal case. Here's how we're going to break it all down. First, we'll introduce you to the key players in this fight. Then, we'll get into the weeds of the three specific complaints that kicked this whole thing off. After that, we are stepping right inside the virtual courtroom to hear the arguments from both sides. And of course, we'll get to the main event, the judge's final verdict. Finally, we'll talk about why this little neighborhood showdown is something every single person living in an HOA should know about. Okay, let's set the scene. We're in a planned community called Pineglen in Show Low, Arizona, and on the surface, it's pretty quiet. But a serious dispute was brewing between one resident and her HOA board, a fight that went from angry emails all the way to a formal hearing with an administrative law judge. So on one side, you have our petitioner, homeowner Kimberly Martinez, and on the other side, the respondent, the Pineglen Owners Association Board, a group of volunteers from this 84-lot community. And right there, the stage is set for that classic David versus Goliath showdown, one resident against the entire system. So, what exactly sparked this legal battle? Well, Ms. Martinez didn't just fire off a vague complaint. She put her money where her mouth was, paying a $1,500 filing fee to the state and submitting a formal petition with 3 very specific allegations. Let's dig into each one. All right, first up, the election. This first complaint was all about the annual board election. Ms. Martinez claimed the ballots that were sent out to all the residents had a major problem. They were missing key pieces of information required by Arizona state law, specifically a spot for the voter's name, address, and signature. Now, that might sound like a tiny technicality, but as you're about to see, it's a really big deal. Next up, we've got the issue of how the board was adding new members. The second problem blew up at the annual meeting. The board announced they were creating 2 brand new official voting positions, an RV lot manager and an architectural review manager, and then immediately appointed people to fill them. Ms. Martinez said, "Whoa, hold on a minute." She argued that was a total violation of the rules. New board members have to be elected by homeowners, not just handpicked by the current board. And that brings us to the third and final complaint, which is all about one thing: transparency. This last point really gets to the heart of a homeowner's right to information. Ms. Martinez had put in a formal request to purchase copies of certain HOA records, something she was legally allowed to do. But she alleged the board secretary just flat out refused, effectively blocking her from seeing official HOA documents. Okay, so the complaints are filed, the battle lines are drawn, and the case moves to a formal hearing. And get this, it was all held virtually over Google Meet. This is where both Ms. Martinez and the HOA board got to plead their cases directly to the judge. So let's step inside that virtual courtroom and hear what they had to say. On that first complaint about the ballots, Ms. Martinez's argument was super simple. The law is the law, and the ballot she got didn't have a space for her address. The HOA's defense, though, was a little more complicated. They argued they left the address off on purpose to protect resident privacy. They even testified that a board member actually went door to door to collect the ballots and then wrote the lot number on each one later to keep track. When it came to the board appointments, Ms. Martinez argued that an annual meeting is for electing directors, not just appointing them. But the board fired back, pointing directly to their own bylaws. They said their rules allowed the board to increase or decrease its membership and to fill vacancies. They argued that this language gave them all the power they needed to add those 2 new spots and appoint people. And on that final complaint, man, the conflict was crystal clear. Ms. Martinez said she made a formal, written request to purchase copies of the records. The HOA's response, they said, "Hey, we got the documents together, and we told her multiple times she could come look at them in person. She could even bring her own printer." They argued they made the records reasonably available for her to look at, but the question is, was that enough? Now, during the hearing, the HOA board tried to argue that none of this stuff had really caused Ms. Martinez any actual harm, but the judge immediately shut that down with this incredibly important clarification. She explained that the hearing wasn't about proving damages. The only question she cared about was simple. Did the board violate the law? Yes or no? And with that, after hearing all the arguments, the judge was ready to issue her final decision. This is it. This is the moment where the arguing stops and the official, binding rulings come down. Let's see how the judge ruled on all 3 complaints. First up, those election ballots. The big question, did the HOA actually violate the law? Well, the decision came down to the plain black and white text of the law. Arizona Revised Statute 33-1812 is not vague. It says the ballot shall contain the name, address, and signature. It doesn't say it should or maybe, it says shall. The board's good intentions about privacy didn't change what the law required.
So the judge found that because the ballots did not have the voter's address, the HOA was in clear violation of state law. That's 1 point for the petitioner, Ms. Martinez. All right, next up, the board appointments. Did the board go too far and overstep its authority by appointing 2 new voting members?
For this one, the judge didn't look at state law, she looked at the HOA's own governing documents. And right there in Article IV, Section 1 of their bylaws, it explicitly gave the board the power to increase its membership and to fill vacancies. That right there was the key piece of evidence. So the judge ruled that the board was acting within the power given to them by their own rules. On this count, there was no violation. The HOA gets the win here. And this really highlights how important it is to know the specific rules for your own HOA, because sometimes they grant the board more power than you think. And finally, the records request. Did the board have to give Ms. Martinez copies, or was just letting her come look at them in person good enough? And once again, the answer was found in the exact wording of the state law. The law makes a really clear distinction. It says records must be made reasonably available for examination, sure, but it also says that on request for purchase of copies, the association shall provide copies. Those are 2 separate requirements. Because Ms. Martinez specifically asked to purchase copies and the board refused, the judge found the HOA had violated the statute. This is a huge distinction for all homeowners to understand. A second violation found against the board. So, let's look at the final scorecard. Ms. Martinez, the homeowner, successfully proved 2 of her 3 complaints. The board was found in violation of state law on the election ballots and on the records request. They were only cleared on the issue of the board appointments. This was a decisive, though not total, victory for the homeowner. So, a split decision, but what are the real-world consequences here? Well, the judge's order lays out not just the penalties for this one HOA, but some incredibly important lessons for anyone living in a planned community. First, this hit them right in the wallet. The judge ordered the HOA to repay Ms. Martinez $1,000. That's 2/3 of her initial filing fee, corresponding directly to the 2 complaints she won. This means the entire community, through its HOA dues, had to literally pay for the board's mistakes. That's a powerful reminder that these violations have consequences. This case leaves all of us with some really crucial takeaways. First, state law is king. It trumps your HOA bylaws and even good intentions. Second, being a volunteer on the board is not a get-out-of-jail-free card. You are still legally accountable. Third, words matter. The case made it clear that a request to purchase copies is not the same as a request to view records. And finally, it shows the immense power of putting everything in writing. Ms. Martinez's clear, written requests were the backbone of her case. That paper trail is your best friend. You know, this entire case really boils down to one person who knew the rules, both the state law and her own community's bylaws, and held her board accountable to them. It's a powerful reminder that knowledge is power. And that leaves us with a final question for you. Do you actually know the rules that govern your community? Because as this case shows, what you don't know can absolutely hurt you.